Good day, Crime Talk aficionados. We have a great show for you today. First, is there really an alternate suspect in the Bryan Kohberger case? Lori Vallow trial, week 1 is done. How's it going? Luigi Mangione's attorneys are trying to get the death penalty thrown out. The Menendez Brothers, well, they get a hearing for a resentencing. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications so that you know when we go live or put up new content. And remember, you can always check us out on any of your favorite podcasting apps. Now, before we get started, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire on anyone here in the United States. The report is literally prepared while you wait, and guess what? You can even get updates sent to you if new information becomes available. You're going to get all types of information. You're going to get information about email addresses, phone numbers, social media presence, whether the person has liens or judgments against them. Do they have a wife? Do they have a husband? Are they divorced? Are they on one of those sex offender registries? And most importantly, do they have a criminal history? Everything you want to know about somebody before you let them into your life. So go to crimetalksearch.com. You're going to be happy you did. Heck, it could possibly even save your life. All right, let's go ahead and get to the docket, ladies and gentlemen. It is Monday, April 14th. Only one day till tax day. I know. A couple of days you just hate throughout the year. Tax day. Anyway, let's go ahead and get to it. Now, as of April 14th, 2025, the alternate suspect in the Bryan Kohberger case remains only a defense assertion without publicly disclosing evidence to support it. Now, the tip mentioned by Ann Taylor in the April 2025 hearing is rather vague, and no specific individual, motive, or any sort of forensic link has been presented to challenge Kohberger's status as the sole suspect in the case of the 4 dead college students there in Moscow, Idaho, back in November of 2022. Now, the prosecution maintains that DNA, phone records, and surveillance tie Kohberger to the crime, with no exculpatory evidence supporting another perpetrator theory. Now, the defense strategy obviously appears to create doubt, delay the proceedings possibly, or mitigate penalties. But Judge Hippler, he gave a deadline, and he will force the defense to substantiate that claim very soon. Without concrete evidence, the alternate suspect narrative risks being dismissed as pure speculation. And it underscores the defense's effort to contest, obviously, the high-stakes case in which Bryan Kohberger finds himself here right now. Now, for those who don't know, Kohberger, a PhD student in criminology at the Washington State University, was arrested back in December 30th of 2022 in Pennsylvania, charged with 4 counts of first-degree murder and felony burglary. The prosecution's case rests on DNA evidence, specifically male DNA on a K-bar knife sheath found under Madison Mogen's body, statistically matched to Kohberger's via investigation through genetic genealogy, which ultimately led to a search warrant so that the prosecution could obtain a known sample to compare that to the DNA, and whatever you're going to call it, touch, transfer, it doesn't really matter. It's DNA. It's there. Somebody's got some explaining to do how it got there. Now, there's lots of ways that somebody else's DNA could have got on that knife sheath button, I'm sure. And I'm sure the defense will bring up all of those possibilities, but it doesn't underscore why it's Bryan Kohberger's DNA. Right? It's not your DNA. It's not mine. It's not Frank, the hardest working man in show business, DNA. It just happened to be Bryan Kohberger's. Next, they also have a lot of surveillance footage. A white Hyundai Elantra, consistent with Kohberger's vehicle, was seen near the crime scene around the time of the murders, approximately that time frame between 4 and 4:25 a.m. There are cell phone records and data allegedly placing Kohberger's phone near the victim's home on King Road, Moscow, Idaho, before and after the murders. We have a witness description. A surviving roommate reported seeing a man with bushy eyebrows wearing a mask, which prosecutors argue aligned with Kohberger's appearance, supported by a selfie taken just hours after the murder. Kohberger's defense has challenged the reliability of this evidence, arguing issues like potential DNA contamination, vague vehicle descriptions, and discrepancy in the phone data. The alternate suspect theory is part of their broader effort to question the prosecution's narrative. Now, like I said, the defense claims of the alternate suspect, Kohberger's team has obviously led by the lead attorney, Ann Taylor, has referenced the possibility of this alternate suspect multiple times, with the most recent mention during the April 9th, 2025 hearing there in Boise, Idaho. Here's a detailed look at what we know. So at the April 2025 hearing, during a motions hearing before Judge Stephen Hippler, Ms. Taylor stated, "We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can." She raised this point while arguing that the volume of discovery was overwhelming, suggestion it might contain undisclosed exculpatory material, and requested the death penalty be removed as a potential punishment to ensure fairness. Taylor did not provide specifics about this tip, such as the identity of the alleged suspect, their connection to the crime, or the nature of the evidence. She described it as a surprise lead, indicating it was only recently uncovered. Judge Hippler responded by setting a May 2025 deadline for the defense to present evidence of an alternate suspect, requiring a factual showing that any suggested perpetrator has a connection to the crime. He emphasized this should be addressed in a separate pretrial hearing to avoid derailing the trial scheduled for August 11th, 2025. Now, in earlier filings, the defense claimed there were evidence corroborating Kohberger being elsewhere during the murder, possibly driving around to go look at the moon and the stars, an alibi the prosecutors have challenged with weather records showing fog and clouds that particular evening. And they've suggested other individuals could have been involved, pointing to the unidentified DNA. There was blood and DNA at the scene that didn't conclusively match Kohberger or the victims, which they argue could point to another perpetrator. The defense has claimed the knife sheath DNA might have been planted or contaminated. And then we have the multiple killer theory. Back in March of 2025 filings, the defense argued one person could not have possibly killed 4 victims in the estimated 13-minute time frame, implying multiple perpetrators. They've also cited Kohberger's autism spectrum disorder, claiming it would physically limit his ability to commit the crime alone. Now, there's been no specific alternate suspect named in these earlier claims, and the defense has focused on showing doubt rather than presenting a definitive alternative. And then we've got some records, right? On April 9th, the defense attorneys referenced a mysterious figure with the initials AI who allegedly made unauthorized purchases on Kohberger's Amazon account. This mentioned in an ex post, but lacks corroboration in primary courtroom documents. Then we got the prosecution has not addressed the claim directly, and its relevance to an alternate suspect remains unclear. It could be an attempt to question the Amazon record showing Kohberger purchased the K-bar knife sheath in early 2022, which prosecutors linked to the murder weapon. The prosecution argues that the DNA on the knife sheath is a statistical match to Kohberger, and no other DNA evidence conclusively points to another individual. The sheath's placement under Mogen's body suggests it was left by the killer, and surveillance footage and phone records place Kohberger's car and phone near the crime scene, and no other vehicle or individual has been credibly linked. While the defense mention of an alternate suspect is notable, several factors suggest it's more strategic than evidentiary at this stage. First, the defense has not publicly named the alternate suspect, provided a motive, or detailed evidence trying another individual to the crime. The vague tip mentioned in April 2025 could be an investigative lead rather than a confirmed suspect, possibly intended to pressure the prosecution to disclose more discovery or just justify potentially delaying the trial. Now, Taylor's comments about the tip came during complaints about the prosecution's handling of discovery, including thousands of pages of documents, surveillance videos, and phone records. Now, claiming an alternate suspect might be a tactic to argue that they need a little more time to access the evidence, especially since they've accused the state of withholding exculpatory evidence, obviously a claim the prosecution has denied. Then we got the DNA. The DNA in the knife sheath is a cornerstone of the prosecution's case, and the defense suggestion that it was planted or contaminated lacking support evidence so far, and there's no other DNA that has been publicly linked to a specific alternate suspect. Unidentified DNA at the scene is common in a shared residence, as the victims lived with roommates and had visitors. Then the crime scene dynamics, so to speak. The defense's multiple killer theory and alternate suspect claim face challenges given the crime scene specifics. For example, 4 victims stabbed in a confined space over a short time frame with no signs of forced entry or theft, suggesting a targeted attack. No other suspects have been mentioned in police reports, and the surviving roommates reported only seeing one intruder. Then there's been various speculation, skepticism about the alternate suspect claim, noting that the prosecutor's assertion that there's no exculpatory evidence to support it, right? Well, others saying, speculation like the Amazon claim, but they lack verification and may reflect online rumors rather than fact. There's a lot of online rumors, ladies and gentlemen, and I've seen some stuff on X that just blows your mind, defies all of reality. Some of these people are living in an alternate universe on both sides of the case here, so to speak. So, raising an alternate suspect is a common defense tactic to create reasonable doubt, even without strong evidence. The defense may aim to highlight investigative gaps or suggest other possibilities. Motive, right? Through the no evidence to support anything. The judge's May deadline ensures they must substantiate the claim pre-trial or risk it being excluded completely at trial. And also, let's face the fact that there are no other potential suspects. Now, early on in the investigation, before Kohberger's arrest, the police cleared several individuals. First, the surviving roommates. The 2 roommates who were at home during the murders were not considered suspect, as one's 911 call and their lack of involvement were verified, as at least to the satisfaction of the police and the prosecutors. The ex-boyfriend of the victim, Kaylee Gonzalez's ex-boyfriend, was investigated but cleared based upon an alibi and no physical evidence linking him to the scene. You see how easy that is, ladies and gentlemen? We're like, I wasn't there and I can prove it. No charges. That's the problem with an alibi. If there was a good alibi defense, right? You're charged, but you had a great alibi, the case probably wouldn't be there. Anyway, then we had a nearby resident. A neighbor reported a suspicious activity, but no connection was established. Then there were thousands of random leads. Tips about local individuals or students were pursued, but none panned out. And as Kohberger emerged as the primary suspect by mid-December 2022, no evidence suggests these individuals are the alternate suspect referenced by the defense at that hearing just a couple of weeks ago. The alternate suspect narrative aligns with other defense efforts, challenging evidence admissibility, motions to suppress the knife sheath, the DNA, Amazon records, phone data, and surveillance footage, arguing they're inconclusive or improperly obtained. And we got the alibi, right? We just talked about it. If this is a valid alibi that could be checked out and the prosecution say, wow, we got the wrong guy, they would do it. Right? The prosecution has a duty not to prosecute innocent people. Anyway, the alibi defense claiming Kohberger was driving alone, which prosecutors counter with weather records and phone pings. Well, it's mitigation, right? They got that problem. Then we got mitigating the death penalty, arguing Kohberger's autism and the discovery burden make the fair trial impossible if the capital punishment is on the table. And then there's also the public perception, suggesting police rushed to judgment, ignoring other leads to counter the narrative of Kohberger as a calculated killer, reinforced by the essay that he did in 2020 on crime scenes, which the prosecutors plan to use. By floating the alternate suspect, the defense aims to shift focus from Kohberger and his proximity to the crime, right, living 10 miles away, owning a very similar car, to a hypothetical others, even if the evidence is quite thin. Ladies and gentlemen, the defense must present evidence of this alternate suspect by May, or the theory may be barred from trial. And obviously, failure to provide specifics is going to weaken the defense's credibility as well. So the trial is set for August 11th, 2025. with the jury selection and potential death penalty phase if convicted. Now, there's obviously a gag order here, so there's lots of statements that, neither the prosecution nor the defense can go into. So obviously what we learn about is from most filings of motions as well as what is said in court. But let's go to a couple things real quick. Alternate suspect. Now, when you endorse various defenses in a case, you do that all the time. As a defense attorney, I've done it more times than I could possibly imagine. First, a general denial, which you don't normally have to endorse. You could claim self-defense, alternate suspect, any affirmative defense you can name. Sometimes I've listed every single one of them, particularly if there's multiple counts. You'll list them all, right? Because you have to put the government on notice for those defenses. And sometimes I know I'm never going to use those, but I endorse them out as an abundance of caution, so that if something comes up, or maybe I want to at least try to argue it. You just never know. These are very fluid proceedings, ladies and gentlemen. And I think that's somewhat difficult for people that, yes, you can watch a trial on TV, but it's another thing to actually defend somebody when you have bad facts and you try and do everything you can. There's not going to be an offer. There's not going to be a deal, but you're trying to use everything you can to your client's advantage. Here, the defense attorneys are doing whatever they can to try and do anything to get the death penalty taken off the table. I guarantee you, ladies and gentlemen, if the prosecution agreed to plead guilty to all counts, open sentencing, right? Go to prison, 4 life sentences plus the burglary, all that stuff, I would almost guarantee you there would be a guilty plea in this particular case. Take it from me. Just your everyday local criminal defense attorney has been doing this for 30 years, handled more murder cases than I can even recall. So the bottom line is, ladies and gentlemen, be suspicious of the alternate suspect. Okay. Every now and then you get a good case, but you got to have something that was there, right? Somebody burglars the house. Oh, they just happened to find a cigarette butt that just happened to comes back to a guy that just got released for burglary. That's an alternate suspect. They find the cigarette butt, they get the DNA, and it's his DNA, but they thought it was yours, right? Alternate suspect, viable alternate suspect, not this, well, there could be something here. We just don't know what. We don't get to do that. We'll see where the alternate suspect goes, ladies and gentlemen. We'll see if the defense can actually produce anything. And I know the defense keeps complaining about everything going on in all these documents, but there are ways to get it done. They've had 3 years almost, ladies and gentlemen. They'll have 3 years by the time trial gets started, almost 3 years, I guess, 2.5. They could hire somebody. They can get interns from the school to work on it. Money and things of that nature are not going to be an issue in a death penalty case. You get hyper due process. And as the Judge Hippler noted, have you asked for more money to get the resources? And Taylor had said she had not. Setting up the ineffective assistance of counsel claim. I think that's what it is. Next, Lori Vallow, 1 week down. How's she doing? That's right. The ongoing Arizona trial of Lori Vallow, which began back in late March, centers on charges of conspiracy to commit first-degree murder for the July 11th, 2019 death of her fourth husband, Charles Vallow, and related charges to the attempted murder of Brandon Boudreaux, her niece's ex-husband. Now, let's give a quick recap of the trial's key developments based upon information that we have up to today. All right. So let's go through this rather quickly. First, Lori Vallow was previously convicted in Idaho in 2023 for the murders of her 2 youngest children, Joshua J.J. Vallow and Tylee Ryan, and the conspiracy to murder Tammy Daybell, the wife of her 5th husband, Chad Daybell. She is serving life without the possibility of parole in Idaho. And in Arizona, she faces charges stemming from this event in 2019, which prosecutors allege were motivated by financial gain. Specifically, a $1 million life insurance policy, her relationship with Chad Daybell, and her extreme religious beliefs involving zombies and apocalyptic prophecies. So, on July 11, 2019, Charles Vallow was shot and killed by Vallow Daybell's brother, Alex Cox, at her home in Chandler, Arizona. Cox, the brother of Lori Vallow, claimed self-defense, alleging Charles attacked him with a baseball bat during an argument over picking up JJ. Police did not charge Cox at the time, but prosecutors now argue the shooting was a planned conspiracy involving Vallow and it wasn't self-defense as alleged. And then you got the case of Brandon Boudreaux, which will go after this particular case, that back in October of 2019, Boudreaux was shot at while driving near his home in Gilbert, Arizona, and he fortunately survived. Prosecutors allege Vallow and Cox conspired in the attempt, though no shooter was definitively identified. Now, Cox died of natural causes in December of 2019, and Vallow, therefore, is the only one charged with the conspiracy to commit murder for her husband. She has pled not guilty to all charges in both cases. Now, the jury selection, which began on March 31st, and then they had opening statements on April 7th there in Maricopa County. Lori Vallow is representing herself, and a decision was made after insisting she knows the case better than the attorneys. Having studied it for years, she has advisory counsel, but conducts her own questioning as well as arguments. Then in December of 2024, she was ruled mentally competent to stand trial to represent herself. Now, obviously, we have 16 jurors, 13 men, 3 women, including 4 alternates, and they were selected from about 200 potential jurors. Many were screened out due to prior knowledge of the high-profile cases, reflecting obviously challenges to get an impartial jury in a county with a population of 4 million people. Now, the prosecution has argued that Vallow conspired with Cox to kill Charles for his $1 million life insurance policy, which Charles had changed to his sister. And anyway, so that she could marry Chad Daybell. Now, Kay Woodcock highlighted Daybell's religious beliefs when she testified, claiming she labeled Charles a zombie or dark spirit named Ned, justifying his death. Evidence would show that Cox staged the scene. For example, placing the bat on Charles' right side despite him being left-handed, and waited some 47 minutes before calling the police. Vallow delivered a brief statement asserting that she and Charles had a happy 13-year marriage. She denied financial motives, noting insurance policies are common, and insisted Cox acted in self-defense. A family tragedy is not a crime was the theme of her opening. Now, the first 3 responders testified, describing the crime scene and Charles' body with no evidence of CPR being performed despite Cox's claim. The testimony continued. Chandler Fire Captain Kent Keller and Officer Daniel Kuhn testified about the shooting scene. Keller noted Charles was likely dead when they arrived and no signs of CPR were given. Kuhn presented graphic photos, including a gun, the handgun, 1 round chambered, an orange duffel bag with a gun box, removed floor section with blood evidence. The bat's placement was emphasized as inconsistent with self-defense. Now, Lori Vallow cross-examined the responders about CPR techniques and the bat, suggesting an inexperienced person might not perform CPR correctly. Her questions were at the time disorganized, prompting judicial reminders to avoid commentary. Vallow's filed motions to dismiss, alleging missing phone data, which is discussed during various recesses. And there's been some heated exchanges. Witness Nancy Jo Hancock, a woman who went on a date with Charles the night before his death, testified about his separation and concerns about Lori Vallow. During cross-examination, Vallow asked if Hancock knew Charles was married, leading to this exchange. Do you go on dates with married men naturally? Hancock, don't flatter yourself, after denying she focused the date was entirely about Lori Vallow. Prosecutors objected, calling her questions argumentative and nothing more than harassment. Then we had a witness, Christina, a friend of Vallow Daybell, testified about her claim that Charles had a dark spirit and her move to Hawaii without telling him. Vallow's questions was brief and less confrontational. Now, Vallow's self-representations led to a couple of procedural hiccups, with the judge correcting her on objections and evidentiary rules. Then on day 6, little family testimony. Adams Cox, the brother, testified he believes Vallow Daybell was behind Charles' death. He and Charles planned an intervention to address her extreme beliefs, intending to record her for their LDS stake president. Adam noted Vallow somehow knew of the plan, despite him keeping it quite secret, suggesting she was manipulative. Kay Woodcock, a friend of CrimeTalk here, cried while testifying about learning of Charles' death via Google. She described his fear of Vallo's behavior, including threats to kill him earlier in 2019. Serena, a friend, recounted meeting Vallo and Chad Daybell at a 2018 Preparing a People conference, noting their close relationship before Charles' deaths. And then we have Vallo's performance. Her cross-examinations were emotional, but often unfocused, challenging witnesses on minor details. Example, Woodcock's memory of a family event. She objected frequently, drawing rebukes from interrupting. And then on subsequent days, no court was held on April 11th. Due to scheduling, the trial resumed today with new prosecution's motions being filed, a subpoena for Bobby Vallo, limits on questioning police witnesses, a third motion to preclude Vallo Daybell's witnesses, specifically Summer Shiflett and Janice Cox, arguing that they are completely irrelevant, and a motion about video observed by Shiflett and Cox possibly related to the shooting. Now, Vallo received these motions on April 14th, indicating ongoing evidence disputes, and testimony details from April 18th are obviously limited. We've been bringing you the video, but frankly, I've been in court all day, so I apologize for not giving you the recap of everything today. I'll do better in the future. Next on the docket, Luigi Mangione. That's right, Luigi Mangione, the one that everybody loves. The man who's got a GoFundMe page for his criminal defense case for murder for Donnelly in federal court in New York, but state court in New York and Pennsylvania as well. But this time, Luigi Mangione's attorney are arguing that the death penalty that they are pursuing by the prosecution is a politically driven violation of due process, citing the Attorney General Bondi's Trump-aligned statements, rush procedures, and prejudicial publicity. Now, the prosecution counters that the crime's premeditation, public danger, and legal eligibility justifies capital punishment, framing it as a necessary response to political violence. Now, this debate hinges on whether Bondi, the Attorney General Pam Bondi's actions, crossed legal lines or reflect permissible discretion, with the defense facing an uphill battle to convince a court to intervene pre-indictment. The case underscores tensions between the federal policy shifts and individual rights, amplified by the high-profile nature of this case. Now, the defense contends that Bondi's directive to seek the death penalty is driven by President Trump's political agenda rather than case facts. They cite Bondi's April 1st, 2025 press release where she stated the death penalty would carry out President Trump's agenda to stop violent crime and make America safe again. They argue this explicit reference to Trump's executive order signed January 2025, directing the Justice Department to pursue capital punishment for several severe crimes, shows the decision prioritizes political optics over impartial justice. The defense calls it arbitrary and capricious, claiming Bondi is following a directive to restore federal executions that Biden had a moratorium on, not evaluating Mangione's case on its merits. Now, the attorneys allege Bondi, the Attorney General, and the Justice Department abandoned standard procedures for authorizing the death penalty. Typically, the DOJ's Capital Case Committee reviews mitigating submissions from defense counsel before a decision is made. The defense claimed they requested 3 months to prepare a fulsome mitigation submission, but were ignored, and the decision was rushed to align with President Trump's policy. The defense attorney argues that this haste violated Mangione's due process rights under the Fifth Amendment, as the process lacked fairness and transparency. The defense asserts that Bondi's focus on the president's directives over case-specific facts rendered any mitigation efforts futile. The motions highlights Bondi's public statement as prejudicial, arguing they taint the grand jury pool before Mangione has been federally indicted. Specifically, her April 1 press conference labeled Mangione's acted as a premeditated, cold-blooded assassin, implying guilt. That's how I would take it. And then an Instagram post by Bondi's office allegedly portrayed Mangione as guilty, further biasing jurors. And then there was a Fox News appearance where Bondi discussed the case that reinforce the narrative. The defense claims these statements violate DOJ guidelines on pretrial publicity and compromise Mangione's rights to an impartial grand jury, requesting that jurors be screened for exposure to Bondi's remarks. That seems fair enough. Anyway, the prosecution, under the direction of the Attorney General and the acting Attorney General there in New York, defends the decision to seek the death penalty as appropriate given the crime's gravity and legal eligibility. While they have not fully responded to the April 11th motion in public filings, because it's only the 14th, their position is pretty much articulated through Bondi's statement and the DOJ announcements. The severity and the nature of the crime, the prosecution characterizes Mangione's alleged murder of Bryan Thompson on December 4th as premeditated, cold-blooded assassination that shocked America. They argue it meets the threshold for a capital offense due to its planning, execution, and public impact. So, the federal charges include murder through the use of a firearm in violation of 18 United States Code Section 924J, explicitly carrying the death penalty as a possible sentence upon conviction, providing the legal grounds for it. The DOJ emphasizes Mangione's alleged stalking, use of a 3D printed pistol with a suppressor, and fake IDs indicate deliberate intent. Then we have the political violence. In Bondi's statement, she labels the killing of an act of political violence, citing Mangione's alleged motive to target Thompson over grievances with the healthcare industry, evidenced by words like deny, depose, and delay on shell casings, and a letter criticizing insurers. This framing elevates the crime to a threat against the public order, justifying the death penalty as a deterrent. Further, the prosecution argues the public setting outside a Manhattan hotel during an investor conference posed a grave risk of death to additional persons, another factor supporting the capital punishment under federal law. So, the alignment with executive policy, the Department of Justice defends Bondi's directive as consistent with Trump's executive order to pursue the death penalty for the most serious, readily provable offenses. They argue that this policy reflects a legitimate shift in federal priorities after the Biden administration's 2021 moratorium on execution, which Bondi lifted on February 5th of 2025. The prosecution likely views the executive order as empowering the Attorney General to make such decisions, dismissing claims of political impropriety as irrelevant to the case's legal matter. Bondi's statement asserts the decisions follows careful consideration, implying a reasonable process despite the defense claims of haste. While details of internal DOJ deliberations are not public, the prosecution may argue that the capital case committee or other review occurred even if abbreviated, and that Mangione's team had the opportunity to present mitigation, their hastily assembled meeting, in late 2024. Then you've got public safety. The DOJ frames the death penalty as part of a broader effort to stop violent crimes and to make America safe again. They argue that Mangione's alleged actions, planning a high-profile murder over months, warrant the harshest penalties to deter similar acts, especially against corporate or public figures. Thompson's status as a father and a CEO is highlighted to underscore the crime's human and societal toll, though prosecutors avoid explicitly tying the decision to his corporate role to deflect bias claims. And then the attorney suggests Bondi's decision was influenced by Bryan Thompson's status as the United Healthcare CEO, implying favoritism towards corporate elites. They argue the DOJ emphasizes Thompson's role as an innocent man and father in Bondi's statement, showing unequal application of justice, as similar crimes might not prompt such a severe response without a high-profile victim. And the defense frames the death penalty pursuit as a state-sponsored murder, arguing it's hypocritical for the government to condemn murder while seeking to execute Mangione. They tie this to the broader criticism of the healthcare industry, alleged in the DOJ motion defending the broken, immoral, and murderous healthcare industry by targeting Mangione, who allegedly his motive involves, obviously, these insurance practices. So, bottom line, ladies and gentlemen, is policies are policies. They're not law. They're not regulation. And the problem with Mangione is he's got a problem because usually when you go in for some sort of mitigation, you all but concede that, yeah, your client did it. because acceptance of responsibility is something that would be part of any mitigation, normally in a death penalty case. Very rare circumstances do they take the death penalty off the table and still let you basically go try your case. I had that happen in the one death penalty case that they were considering. We got them to not go forward on it, but they didn't require us to basically make any admissions. But that was very unusual. It was a cold case, and there were lots of legal issues with that. So we'll see where it goes for Mangione. My guess is once he's ultimately formally indicted and charged in the federal system, appears and are not guilty, the United States government will, within the time limits allowed, state that they are going with the death penalty or to pursue the death penalty. Now, obviously, Mangione's presumed to be innocent, and he's entitled to that presumption, and we'll see where it goes from there. But that's the arguments on both sides. Next, the Menendez brothers. That's right, Eric and Lyle Menendez. They get a resentencing hearing, and they can continue despite opposition from the district attorney, a judge ruled late Friday afternoon. Now, for those who don't know, both brothers were sentenced to life in prison without the possibility of parole at age 18 and 21 after being convicted of murdering their parents, Jose and Kitty Menendez, in their Beverly Hills home back in 1989. Now, the former district attorney, George Gascon, one of the worst district attorneys in America, asked a judge last year to change the brothers' sentence from life without the possibility of parole to 50 years to life. That would make them basically eligible for parole immediately because they committed a crime when they were younger than 26 years of age. But Gascon's successor reversed course. Nathan Hochman submitted a motion last month to withdraw the resentencing request. But in light of Hochman's opposition to the resentencing, a district court judge, Michael Jessic, ruled that the court can move forward with the hearing. Everything you argue today is absolutely fair game for the resentencing hearing next Thursday. Now, Hochman's office said that they could not support the brothers' resentencing because they had not admitted to the lies they told during their trial about why they killed their parents and didn't fully recognize acknowledgement and acceptance of complete responsibility for their crime. You kind of notice that, ladies and gentlemen? One thing you oftentimes say at a resentencing is that, Your Honor, my client has accepted responsibility for his actions. It's the first step towards rehabilitation, accepting responsibility. It's just something to think about. Next, let's not burn down the governor's mansion. The suspected arsonist arrested over the firebombing attack of the Pennsylvania governor's Josh Shapiro's home shared disturbing photos on social media, including pics of him pointing a gun at the camera and appearing to breathe fire, as well as a photo of an embroidered flaming Molotov cocktail. Please meet Cody Balmer. He was arrested Sunday evening and faces charges of attempted murder, terrorism, aggravated arson, aggravated assault for the 2 a.m. fire at the Democrats' residence that he resides in as the governor. Anyway, no motive has yet been given for the arson attack on the governor's home, but a Facebook account believed to be run by Mr. Balmer, according to sources, include a number of radical posted images of guns and at least one apparent call for violence. He told police he'd planned to beat the governor with a hammer if he had in fact encountered them, according to the arrest affidavit. Now, Balmer also shared multiple left-wing anti-capitalist posts on his Facebook, and his home appears to have been foreclosed last year, according to court records. Wouldn't you know it, ladies and gentlemen? What do I say all the time? Communists ruin everything they touch, don't they? Anyway, Balmer appears to have expressed far-left beliefs on social media and in recent years attacked both President Trump and Joe Biden. He said once on a post, Biden supporters shouldn't exist. He wrote in a Facebook post back in 2021, where were you on his first run? Well, aware of the trash he is. As for the second, still knew what scum he is. Now, why didn't y'all forget? What? Because he did. Anyway, R.I.P. Joe Biden. Whoops, that's in May. Not my president, he wrote in another post, while another read, knowing is half the battle, the other half is extreme violence. Crazy people, ladies and gentlemen. Have you ever noticed how those we're talking like Antifa, commie, active, you have to share your ideas, right? I'm a firm believer of First Amendment. Put your ideas out there. You got to put your ideas. They have to withstand public scrutiny. They have to be challenged by both sides. But have you noticed and we're talking like the commies, right? It's all believe what I say or they resort to violence. Like I said, communists ruin everything they touch. Next, this day in legal history. On April 14th, 1865, President Abraham Lincoln is assassinated by John Wilkes Booth at the Ford Theater. Obviously a pivotal crime sparking nationwide legal manhunts and conspiracy trials. And then also on this date, Booth's co-conspirators attempt other attacks, including Lewis Powell's assault on the Secretary of State, William Seward, leading to arrests and executions. And then on April 14th, 1894, the first federal income tax law is enacted, later struck down in 1895, shaping the early tax legality debates. Hence the reason they had a constitutional amendment, because there's nowhere in the Constitution for the government to tax the people, right? They wanted to be free. They were going to get their money through trade and tariffs and things of that nature. Where have I heard that before? Anyway, on this date in April 14th, 1927, the United States Supreme Court upholds Lum v. Rice, affirming school segregation for Asian Americans, a legal precedent later challenged in civil rights laws, obviously wrong. And on this date in 1941, the U.S. Justice Department begins prosecuting draft dodgers as World War II ramps up, setting legal precedents for conscientious objection cases. And then on this date, April 14th, 1970, the Green v. County School Board ruling by the United States Supreme Court pushes for faster school desegregation, strengthening legal enforcement of the civil rights. And then finally, our dumb criminal of the day. A Missouri man who fled the scene after crashing his car into a come-and-go convenience store's front window claimed his Crocs got caught in the pedal, causing him to accelerate into the business. That's right, Crocs, ladies and gentlemen. Ugliest shoes ever created. Or people that have them, love them. Love young kids, you slip them on, you go. Not really my style, but like I said, I know people that love them. Anyway, the police allege that security footage recorded by Dale Hammett slamming his 2012 Dodge Ram into the convenience store on Thursday evening, late in February. Now, Hammett immediately backed up and left the scene without providing any information to the store owners. That's called leaving the scene of an accident. The crash resulted in damages of about $3,700 to the come and go, which is about a half mile from Mr. Hammett's residence. In the crash's immediate aftermath, Hammett twice returned to the store, though, driving the same truck and entering the business when he spoke with an employee, and he never claimed to be the actual driver. Hammett even looked at the security video of the original incident with the worker. When a cop arrived on scene, Hammett denied being the driver and his truck being the one involved. However, security video showed it was clearly Hammett and his truck. When later questioned at his home, Hammett reportedly confessed and stated he was driving in his Crocs and they got caught in the pedal, causing him to accelerate into the building. Hammett added that he had freaked out and then fled the come and go. Now, according to the summons, Hammett has been charged with leaving the scene of an accident with property damage exceeding $1,000, a felony, and he's scheduled to be in court on May 14th. If convicted, he could spend up to 4 years in prison and a maximum of a $10,000 fine. Mr. Hammett, I mean, at least you confessed, I guess, right? Not that you had to, but you're a dumb criminal today because you went back, and then when confronted with the evidence, you lied about it. Not good, right? Remember, if you're going to talk to the police, you have two options. Keep your mouth shut, or you're probably going to tell the absolute truth, which usually isn't going to help you. But at least it's kind of the first step to acceptance of responsibility, if you know what I mean. Anyway, Mr. Hammett, you are a dumb criminal of the day. All right, everybody, thanks for watching. I hope you enjoyed the show. Have a wonderful evening. We'll see you tomorrow. And remember, the Constitution matters.